Hello, neighbor. I'm Robert Burns, and welcome once again to another edition of Sound Off Louisiana. Today is episode 7 of our series of features that we're doing involving former Alcohol and Tobacco Control Commissioner Murphy Painter. I think the last feature was probably our most viewed and had the highest interest level in terms of the specifics of the criminal trial from late 2013. As everyone knows, Mr. Painter was acquitted on all counts. And today he's going to talk to us about the civil trial. You will remember from previous episodes that trial, that case was filed a little before the 1-year prescription period from when Mr. Painter was terminated. So we would be in August of 2011 or so. And I'm going to throw it over Mr. Painter's way for him to let you know what all's been going on in the civil trial from its outset until whatever point he'd like to. And by the way, I have attended, I think, just about every hearing for this civil trial, and there have been a bunch of them. So with that, Mr. Painter, how about you tell us all about the civil trial?
Thank you, Robert. And this is certainly turning into a pretty good saga, I guess, as far as things go. And I mean, I've left 3/4 of a lot of issues out. It could go 20 times more than what we've done so far, but I apologize for all that if it's boring anybody. But anyway, after the last segment that aired, I got a call from a retired, 30-year plus law enforcement officer that said, man, now that we hear the criminal part of what happened in that and how that come about, obviously, all that was derived from the civil part of it, so you need to really share with everybody so they can understand the civil side of how all that started. And I reflected or tried to let everybody know and understand that when I filed suit in August of 2011, which was right before a year of all this taking place, and all the hoopla that had gone on with the news media and the search warrants and the statements from the Inspector General Stephen Street and all that trying to make me look like a bad person. With all that going on, in a year later, there was not one law enforcement agency or any civil people looking at me for any infractions of anything that had to do with database entries or anything else. There had not been one individual file, even with all this publicity, and jump up and say, I've been infringed or done something wrong about anything that I had done that involved any of those databases or anything as Alcohol and Tobacco Control Commissioner for 15 years. So anyway, to lead up to the deal, to us to get to there, Kelly Swear had filed suit against me shortly after Shane Evans had produced his affidavit for the search warrant, where he implicitly said that he had gotten a statement from Swear saying that I had stalked and sexually harassed her for over 2 years, and I knew emphatically that was a lie. As far as if Swear said it, that it was a lie, because nothing like that ever happened either. But anyway, so she filed suit against me. We went through that process, and before she could ever be deposed or anything, the state paid her close to $100,000, with her lawyer saying that she needed the money to get out of town. So which is what she did. Now, they also tried to make me sign something saying that I would have a permanent restraining order against me in that settlement, and that I would be giving up my right to file suit against her for any defamation or anything that as a result of that suit. And I refused, and I was representing myself at the time, and I refused, and that's a whole nother story. It'd take a half an hour, 45 minutes to go into. that scenario, but they paid her extra money for her to accept that, like I said, for her to get out of town. I'm in June of 2011. That suit is over with. No fault against me. Nothing ever came out of that where they said proved or I did anything wrong. And again, she had never been deposed at all to verify under oath whatever her allegations were. So in August of that year, 2011, I filed suit against her for defamation. I filed suit against the Inspector General's office for defamation. And I filed suit against the governor of the state of Louisiana, Bobby Jindal, and his people for their firing me for not obliging by their wanting me to sign or to issue a permit that even the lawyers that represented the people that brought it to me was saying they were asking me to sign something illegal, but that I had the authority to make an exception to that. Now again, for all you legal scholars out there, you go figure out and show me some jurisprudence where anybody can sign something or make a decision to sign something that's or put something in play that's normally against the law, and you make an exception without a court ruling or somebody telling you to. But be that as it may, I mean, it happened and it's still going on. But
well, and I'll just interject for just one
Sure.
second. I don't want to stop your train of thought, but if I could recall correctly, you, and I think you've said this in a previous feature, that you said, look, I will issue the license, but I need a letter from you all indicating that you've directed me to do this, and the response, as I recall correctly, from the attorney in question, and we can name him if you want, said basically that wouldn't be an efficient use of my time. Am I?
well, I mean, I don't mind saying the name of Stephen
No,
Wagensback, who
right.
was the chief counsel at the time, or the chief of staff for Bobby Jindal, and also from Ascension Parish, where I'm from, and also the uncle of, the nephew of a political adversary of mine. No harm there made either. But anyway, he basically told me, or gave me the option to issue the permit, and that they said it was legal and for me to do it. And I said I needed a letter. I wanted the
Right.
paper trail.
Mm-hmm.
That if I issued that it was against everything that I'd done for the last 15 years, and I know things change or policy changes per se, but policy is supposed to change by a court decision or by the legislature changing the law. If I was going to change whatever policy that is based on their deliberation or understanding of what the law was, I wanted to be a team player, and I said, just give me a paper trail, give me something saying you say this is okay as you telling me, and I'll issue the permit. And basically there was some dialogue. He said that wouldn't be an efficient use of my time.
That's what I remember.
But basically what he said was, is you're not getting the letter, you're
Right.
not getting the paper trail.
Right.
And I made it plain and clear that then I was not going to issue the permit then. And that was on the Wednesday before the Friday that I was fired, and I documented all that. And guess what happened to the documentation, ladies and gentlemen? When I got my computer records back and got my phone records back and all that kind of stuff, all that's disappeared. There's no record of any of that. So my word against whoever it is, but I'm just sitting here telling you that's what happened. Okay.
And I didn't mean to throw you off
That's
track.
okay. But the suits start August of 2011. We start going now. Now again, nobody is investigating me for anything. I'll go back and for the timeline purposes and get the records later and find out that, on September or the first part of October of 2011, after I filed suit against the Inspector General, the U.S. Attorney's Office starts issuing subpoenas saying that they want the records of alcohol and tobacco control records, of my records from there, which they got at that particular time. Then I don't want to go through all that other scenario. I told you all about that when we were talking about me getting the private investigator license,
Right.
what went down, that didn't go down, but anyway, so the process starts. Swear's civil suit starts moving forward real slow. You know who her lawyer is, and that's that. But the deal with the Inspector General and with the governor, that started moving pretty fast. Now again, I don't know anything about any investigation that starts in October. That's all secret stuff. So this is moving forward in the 19th JDC, and basically, not to belabor everything, because we're only talking about 11 years, 10 years of adjudication in this matter. But basically, as far as the Inspector General case went, Taylor Porter and that firm was representing the state. There's some issues with that I could bring out, and maybe later or whatever, but be that as it may, that's who the law firm was, and they come into court. No adjudication ever been done on me. Every word out of the lawyer's mouth is that I'm a crook, and all they doing is doing what they were supposed to do to a crook. And no alleged, no nothing. 60 people in the courtroom, sometimes 40 people sitting up there calling me every word that you can do, and fabricating stuff also that allegedly the Inspector General uncovered in the investigation that I did or didn't do. But anyway, so that goes through that process where the judge rules in my favor, 19 JDC judge rules in my favor every time. They appeal the case to get it thrown out. This first part is to get it thrown out, motion to strike or whatever the process is, and no cause of action.
Correct.
And we go through the process. It goes to the circuit court, to the Court of Appeals. The Court of Appeals agrees with us that we have enough evidence to pursue this case. It goes to the Supreme Court. The Supreme Court rules that we have enough evidence against the Inspector General to pursue this case and to go forward with it. So we in great shape there, allegedly. Then the governor's case, that his side of the case goes up. The judge, 19 JDC judge, rules in our favor, and it goes to the First Circuit Court of Appeals. Well, the First Circuit Court of Appeals agrees with us also that we have plenty enough evidence and information to pursue this thing civilly from the point of view that the law allows, and they rule in our favor too. Now, all this is before I ever get indicted on anything, okay? So I'm sitting here in pretty good shape now, or thinking that you're in pretty good shape. Everything's going the right way. Well, and I don't remember exactly the timeline where it fits in with the criminal trial or whatever, because I was indicted, as I've said before, on 2012, May of 2012, and went to trial in December of 2013. So there's a lot of time in between there that all this stuff is floating around. But in the meantime, with the governor's part of this, they appeal that decision, just like they did in the OIG's part, to the Supreme Court. Well, with the OIG decision, when it was appealed, it was in a timely manner. Nothing sat around and waited a long time, and we got a result back from the court. Well, all of a sudden, with the governor's part, the Supreme Court's not doing anything with it. It's just there. I know as a non-lawyer, I will get some criticism for saying, or somebody to say, I don't know what the hell I'm doing or whatever else. But I've only been in this business for 50 years, and I mean, things flow, or especially government, even though it's slow sometimes, it's supposed to flow in some kind of sequence. And all of a sudden, this wasn't flowing at all, and nobody was giving any reason why it wasn't flowing. Now, I kept being told, just don't worry about it, don't worry about it, be patient. But I mean, months went by. Months and months and months went by without the Supreme Court making a decision whether they were going to accept the case and rule on what had been argued so far, or whether they were going to deny them access to that court, which would have been in my favor also, and said that that lawsuit could have went on. And if they'd have ruled in my favor, this thing would have been over with immediately. This never would have went to trial. It never would have went anywhere else in that particular deal, in my opinion. So anyway, so 6, 8, 10 months later, while the Supreme Court was waiting to rule, and I'm an investigator. I don't want to say I'm the best in the world, but I'd like to think I know what I'm doing. And in investigating work, you connect dots, and people don't do anything unless there's a reason to do it. I mean, it might be that they're lazy, but that's a reason why they're not doing something.
Mm-hmm.
So in this particular situation, there's nothing being done. I'm sitting back trying to figure out what's not being done, then all of a sudden the light goes off real quick. The panel of judges that ruled in my favor on the First Circuit, well, they got some people retiring on that panel that voted that I had a case.
Mm-hmm.
6, 8, 10 months later, might even been longer than that. If you want to be an investigator, you go check and see it, and see that I'm telling the truth. As soon as the new judges are in panel on the First Circuit after the election, as soon as that happens, the Supreme Court doesn't rule on that issue. They put out a ruling that says, we don't want to rule on this right now. What we want to do, we see some issues with it that we want the lower court to clear up.
Ah.
We want the appeals court to clear up before we rule on it. So we sending it back to the First Circuit for them to make a ruling. Well, guess what? A new panel gets the case, and they reverse what the other panel said. And this has all been argumentative, but when it first come out, this was what was told to me. Now, lawyer talk since then is lawyers want to say, well, that's not exactly what they ruled, or that's not what happened. But I was told in the beginning, once they ruled, they overturned the deal, that what they ruled was that, yes, I'd file suit against the governor and his staff and all them people under the Whistleblower Act. And yes, that they agree that in all probability, I'd been asked to do something that was improper and very even possibly illegal.
Okay.
But because I did not commit the act as instructed by them, that I did not fall legally under the Whistleblower Act, so they were denying my access to the courts under that request based on that idiom. So then we appeal that to the Supreme Court. Well, then guess what? The Supreme Court denies our writ, and we stuck with what the First Circuit reversed itself to rule.
Mm.
But okay, so now the future president of the United States is out of his obligations here, and his staff is out of their obligation here.
Mm-hmm.
But I still have the Inspector General in tow, which I guess was the 50-50 part of this, so to keep things in some fashion of rightful legality. But so in the meantime of all this happening, I'm having hearings. Now I'm indicted. I go to trial, and all kind of stuff comes out in the trial that we didn't know before. And then the first case to really move forward was the Swear case, where she had got that moved to federal court, which is another deal. But anyway, in that case is where she was finally put under oath, and Shane Evans was finally put under oath, and both of them under oath in a federal court admits, first Shane Evans, that she didn't give him a statement as he has swore to in an affidavit to a judge. And then she came up after that and affirmed that she had never used the words and never said that I had stalked her or sexually harassed her any time in any accusation that she'd ever made. Now, once that, and the jury settled on my side and said that she did defame me. Now, if that jury ruled that she defamed me for saying that, then sure in the hell Shane Evans defamed me. And the OIG's office defamed me for doing the exact same thing. And that's the argument where we are at this particular point in time with this particular civil issue, is to whether that and all the other stuff that was made up by the Inspector General's office defamed me. Now, the only way that they had any chance, which is what's coming up in legal argument now, and again, I mean, it'd take me 5 hours to go through all of the rigmarole and everything that led us up to this particular point. But the only possible thing that could give them any recourse or any relief at all was the fact that I was indicted, which is what they're hanging their hat on and saying that, oh, well, we only did what we were supposed to do, and the federal government made their own decision to indict this man based on the information that we had accumulated and presented to them. Now, again, I mean, I've been around long enough. Have my eyes wide open enough to know and realize and understand that what I'm alluding to is some kind of backdoor relationship between Inspector Stephen Street and his old friend, or some of his old friends that are working at the U.S. Attorney's Office now that he used to work with at the Attorney General's office, or any other kind of collusion of anybody's situation. But I'm still sitting here and will say till I die that I did not commit any crime, or I did not do anything in my tenure as the head of Office of Alcohol and Tobacco Control that would warrant or lead to anything criminal or to be indicted by anybody. And that there was absolutely nothing in the Inspector General's report that reflected any wrongdoing on my part, other than their expose of trying to make something a crime that is no more a crime than jaywalking on the street outside. That's an infraction. It's not a crime. And I'm not even. I didn't even do any infractions on anything that they sitting here trying to make people believe that took place. That was nothing but a CYA deal, and should have absolutely nothing to do with whether they lied or whether they fabricated or whether they were told by the general administration to take me out in order to and they didn't have to take me out. I mean, I would have resigned. If they had called me to that office that day on August the 13th, I was more than prepared to say that that I could not fulfill the wishes of people that had no respect for jurisprudence and had no respect for how laws were decided or policy was decided in the past, and that was sitting there telling me, we're going to tell you what the law says and we're going to tell you how to respond to it. Well, all I wanted them to do was to tell me, put it in writing. That's all, is just put it in writing. But I went there fully with the wishes that if Bobby Jindal and Stephen Wagerspack didn't want me working for them because I couldn't fulfill what they wanted me to do, I would have left there in a second. And I'm enough of a professional that unless somebody would have pointed a gun at me or would have tried to get me in trouble for something somewhere down the line that they were trying to use against me, that I would have left and went by the wayside. I had job opportunities that I could have gone to, and I also had political opportunities that were that were in place, which was another reason, and would be another whole 10-hour story about how that reflects on what happened in this particular situation and the connections there. But like I say, be that as it may, I would have resigned and went by the wayside. I probably went to work in Washington, D.C. somewhere as a consultant for alcohol control, or run for office somewhere, and like the American Constitution allows honest people to do. But anyway, they chose to bring me in and to say, man, you've done a hell of a job. And it was just like them telling that coach on that baseball show what the hell ever it is, Kevin Costner, when they were letting him go as a catcher. Oh man, you did good, you did this and all that. There's nobody better than you. But however, and the however that it came to me is that some unnamed law enforcement agency is investigating you for criminal offense. And I sat there and said to all of them, and I'll go through the process again, Elizabeth Merle, Stephen Wagerspack, and Mike Edmiston. That's the three people in the room. And Mike Edmiston, state police, I knew him his whole career. I ran driver's license checks for him when I was probably a radio operator in Ascension Parish, and everything else that had to do with those systems. I know everything about him, everything that took place or happened. And he knew damn well there wasn't nothing that I had done that was a crime or wrong or whatever else. But anyway, that's the three people, and I told them that I would resign, but I'm not going to resign if somebody's accusing me of something.
Yeah.
Go investigate this thing, and when you finish the investigation and you find I didn't do anything wrong, then come back to me. And if the governor still wants me to resign, I'll be more than happy to go by the wayside, vacate this thing. But you see, the Saints was starting their first game a week later, and that alcohol beverage license wasn't in place, which gave Anheuser-Busch an exclusivity to that situation down there. Now, you can go check that law if you want, and if it's still going on today, it's still illegal today. Now, to be legal, somebody has to, or the rules, somebody's got to complain about it, and then somebody's got to enforce it, and then somebody, they get a right to argue it, and it goes to court. And then the courts decide whether it's right or wrong. Exclusivity is against the law, not only in alcohol beverage law, but in every other situation, also in the fair trade laws of the state of Louisiana and everything else. Now that's a whole nother show. That's a whole nother probably 10 segments if somebody would want to listen to that deal about how all that went down. But
can I interject for just
sure.
1 second? As you pointed out, and our viewers may remember, no sooner had you been shown the door that your interim replacement, the liquor license gets approved, and during the criminal trial, this gentleman was placed up on the stand, and he said, well, that's a signature stamp, and he denied that he had actually placed it on there, to which Mike Fowler said, well, you do realize that you're responsible for your signature being on this document, whether you were the one who physically put it on there or not. And he kind of gave a deer in headlights kind. I believe Mike Fowler reminded him of a case you can Google, signatures are not ornaments. So the bottom line is you weren't even out the door before that liquor license became reality. Am I correct?
well, that was the whole why it had to be immediate at that particular time, was to save that situation. And again, that's a whole how that deal's come about, and the people that came to me with that idea to start with, and the segments of how it went for 6 months from like February, March, because the legislature was in session then, and a certain lobbyist came to me and with the deal, and the people from the Superdome, and mainly started the process of trying to figure out whether I was going to go along with the gig or whether I wasn't going to go along with the gig. And I'd never went along with any gig in 15 years, and had been rewarded for it in the past. But it was a different day and a different group at that point. Now, as Shane Evans admitted in court that he fabricated the affidavit about whether Swear gave him a statement or not, and he had been a major part of all this before. We didn't even know anything at this particular time about some of his other reports and stuff. But anyway, we decided to add him to the lawsuit as personally, for his personal part as supposedly a veteran law enforcement officer who knows everything about everything, that he should be part of this gig the same way as some other people in alcohol and tobacco control that were working for me, that fabricated and broke ranks and didn't follow any form of chain of command or whatever else in this deal, and because they were under investigation at the time for different things, but they wound up winning. I wound up on the outside, so I don't know what that means, but anyway, so for about 3.5 years, 4 years, we've been arguing or going through a court process as far as whether Shane Evans should be held personally liable or not in this matter, and the ruling would come later before a jury trial or something, but the fact of whether he should be part of the case or not was again a summary judgment deal, and also a motion to strike or whatever that was being done. Went back and forth 3 or 4 times until in 2018 to 2019, the court finally ruled and said that and allegedly the argument is as to whether they have the Inspector General's office and any employee of his has a First Amendment right to say anything they want to say while they're allegedly working as a government agency or a government officer, whether that gives them a First Amendment right. Now, the case law is real clear on that. I mean, it's clear as a bell. But anyway, that was supposed argument. It kept coming back from the appeals court. 19th JDC judge kept ruling in our favor, said he was supposed to be part of the case, and then the appeals court would kick it back, and we'd amend it based on some new information that came in, and then we'd go back and forth. Like I said, 3 or 4 times that took place over a year or two period, which just extended this thing even that much further down the line. But they finally ruled and said that, and I was only going by what I was being told at the time. I had 2 lawyers, and I'd been a little bit frustrated with 11 years of wrangling to try to clear my name on this matter when everything is clear as a bell. I mean, if you go for a federal jury and get found not guilty, it should have been fairly simple. That the next thing the state would have done would have been come and say, look, we're sorry, all this happened, and you know, let's try to make you whole or get you back into some kind of situation to take up for all the stuff we caused you. But all that did is make things worse, because again, at that time the guy was still running for president. And they had all kind of other political implications that still were going on with local politics and some of the people I mentioned so far. But anyway, so finally the court rules and says that we let him out the case. Now, I'm being told by lawyers that, the clerk, well, let me finish. The 19th JDC judge ruled in our favor that time. It goes to the appeals court. We'd added a whole bunch of new information in there that kind of nailed everything to the cross as far as what went on. Hard to get by with it, but anyway, so the appeals court ruled and said that appeals court said and ruled that they were letting him out the case. I was told that, well, they made an error. They ruled on the fact. They ruled and said that he had a First Amendment right, and we were going to appeal it. So we appealed it to the Supreme Court. The Supreme Court of the state of Louisiana, and they said, nope, he's out. Now, again, I didn't look at anything. I'm listening to lawyers. After, again, 11 years, you get tired. Believe it or not, I didn't have a gray hair before I started. But anyway, so out of the clear blue, I'm sitting there scratching my head, wanting to believe in the system, and trying to figure out my next move. And I get approached by one of the lawyers that says, now let me frame this also. Shortly after that happened, the lawyer that handled that part of the case for me resigned from being my lawyer and went to work for the state. Okay, and the Department of Transportation, by the way, as a lawyer. So he also supposedly had an agreement with DOTD, as all the lawyers do, that they can still private practice stuff as long as it doesn't involve the state. Well, being at this particular point that Shane Evans wasn't working for the state anymore, he works for the coroner's office, that there was no conflict for him, this lawyer, to file that ruling with the Supreme Court, because he was absolutely adamant that the Supreme Court and the appeals court had erred in ruling and saying that Shane Evans or the OIG's office had a First Amendment right to say what they wanted to say, even though it was a lie. So anyway, so we filed with the we filed with the Supreme Court of the United States of America. The day that those papers were served on Preston Castile at the Taylor Porter office, who is representing, no conflict here either, was representing Shane Evans and also representing Stephen Street in the matter. The day that those papers hit his office, he left that office and went to the governor's office and complained about my lawyer. Oh no, I'm sorry, I'll take that back. I apologize, Preston. The first thing he did was call Stephen Street and tell Stephen Street that we had filed an appeal on the Shane Evans case. Well, then that evening, the next day, whenever else, according to an affidavit that I have from my lawyer of what he was told, Stephen Street went to the governor's office and demanded this governor now,
Yeah,
this
we're not talking about general now.
administration,
Okay.
this administration, this governor. Now, he didn't talk direct to the governor, he talked to a person right under the governor, and demanded that my lawyer be let go of his job with DOTD because he had filed that appeal on my behalf. Now, he was notified that same day that the complaint had been filed based on him appealing that decision, and that they wanted him fired, but all they were supposed to looked at it that he didn't violate anything because Shane Evans wasn't a state employee anymore, blah, 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 all that stuff. And if it got something against him, it wasn't going to impact the state, other than maybe that he might have to tell the truth, or he might have to be a party on his own and testify that somebody in OIG is the one ordered him to do whatever he did. Now, that's hypothetical and that's an opinion. But I mean, that's what the factors are going on here. So 2 days, 3 days, whatever else goes on, they come in and they fire the lawyer. Fire him. Well, he's lucky enough under that particular situation. He had civil service deal where he files an appeal with civil service, but he's out now. They didn't ship him out. Lo and behold, 5, 6 months later, the process, whatever it is, civil service rules on his side and orders them to give him his job back.
Okay.
That he was fired inappropriately. Now, ironically, from what I gather, nobody went into identifying what I just told you as far as the reasons why. They simply said that the wrong appointed official is the one that fired him. So under that circumstance and situation, he really wasn't fired by the proper person, so he needs to get his job back. Well, again, from the affidavit that I have, from that understanding, is that DOTD came to him and said, well, there's no reason, I mean, you can't work for us, you'll never trust us again, blah, 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 all this stuff. And being you can't trust us again or whatever else it is, how much will it take for you not to want your job back? And they, from what I understand, it's probably secret, I know the amount. But I'm going to honor that part of it.
Sure.
But it was hundreds of thousands of dollars that was given to him to not take that job back. Now, it's a whole nother segment for me to go into as to what happened since then, as how that should have affected my case in this particular situation. But that hasn't played a part yet, and obviously Taylor Porter is doing everything that they can to keep that from being part of this case. as much as they trying to keep anything else that we sit here talking about as being part of this case. And it's still pending, and there's some stuff coming up with that, supposedly in the next couple of months. But the last part, and I don't know whether Preston Castile is still the lawyer in this case or not. I've heard that there might be somebody else filing stuff on behalf of Taylor Porter and not him, which that would be an interesting thing also, if that is taking place. But be that as it may, the last thing that was come up or that was filed before COVID, which we lost 2 years because of that in this court process, is that the thought process is that because I was indicted, that all these things don't matter, and that because the judge, they allegedly ruled that that they had First Amendment right, and Shane Evans didn't do anything wrong based on that decision, that therefore, if he didn't do anything wrong, the OIG didn't do anything wrong, and they want to throw all this out. Now, it really behooves me to sit here and have to say this or go through all this stuff on this forum in order for it to be said before somebody knocks me off or before I go by the wayside after 11 years in this matter. But the bottom line of that case that they're trying to use, or the ruling where they're trying to say that they gave Shane Evans and the OIG First Amendment rights, when January the 4th of last year comes along and a case comes out, and I think the proper way to pronounce it is Lessard.
David Lessert.
David Lessert's case, where he had argued with the OIG and the same people that the OIG and their employees did not have First Amendment rights. Didn't have First Amendment rights to say whatever they wanted to say, and guess what? The same court and the same people ruled in his favor that ruled against me. So I decided to look at it myself instead of believing what I was being told, and I'll read the case and I'll go look at my ruling. Well, the court never ruled in my case that the OIG had First Amendment right. They say in their expression that was the argument that was being brought before the court, but that they didn't have to rule on whether they had First Amendment right or not, because the affidavits and the paperwork that was supposed to be submitted according to civil law had not been submitted in my case timely. Had not been submitted timely, so therefore they don't have to rule anything on it.
Wow.
They ruled that it wasn't filed timely, and that's the only reason that Mr. Evans was let out of the case in this particular deal. Now, there might have been some other reason come up, but it certainly didn't give, that court decision did not give the OIG's office any expression of a First Amendment right to lie and cheat and say whatever they want to hurt somebody in any particular deal. And I mentioned in one of the other things 3 cases where this has taken place, and I'm gonna let those people handle their own stuff or whatever along that line. But I'm sitting here telling you, or wanting the world to know and to understand all of the stuff. And again, it would take 100 of these interviews for me to tell you every little bitty thing that took place, that smells, or every little thing that took place that wasn't normal in just my particular situation. So I can imagine, me as a law enforcement officer that's been working in the system since he was 18 years old, again, that knows and understands how the system works, and when it ain't working that way, then I mean, you gotta hold your nose and ask, well, what the hell's going on? But anyway, that's where we stand right now. That's the civil side of this particular thing. And in my opinion, the only reason that I was so-called indicted and put through what I was put through was, and to the extent that they did, was an event to try to get me to plead guilty to something so that they would not have an opportunity, or that I would not have any opportunity to benefit in any civil suit from the wrongs that was done to me. As I guess I know what being a political prisoner is, because that's what I was. I'm a political prisoner for trying to do the right thing for the right reasons.
So after a protracted period, Shane Evans is out, but many of the other defendants remain in, correct?
The only other defendant is the Inspector General's office, Stephen Street and the Inspector General's office.
Oh, okay. Well.
Oh, I'm sorry. And there's some other defendants that have never, that's a whole nother deal that would take another hour to explain. There are some other defendants in the case, former ATC employees and stuff, but they have never been, I don't even know if they've ever been served. It's just been, the right has been reserved to put them in when the time comes or whatever, so.
Well, you still got the big man and you got the agency itself, right?
I got it in a fair fight, you know.
Yeah, I know. I don't mean anything was handed to you.
As far as a fair fight goes, whatever that means, and when you get lawyers involved, sometimes it ain't necessarily fair as far as what goes down.
I think you've pretty well exemplified that.
Right or wrong doesn't necessarily mean anything either, and I'm not foolish enough not to understand that from whatever point of view that needs to be looked at. I mean, we went through a judge for 10 years, and they ruled in my favor every time. We've been given, I'm on, since they left, retired, I'm on the second one now that has come in, and I just want to say I hope and pray I have all the faith in the world in the honesty and integrity of the system, and look forward to the opportunity to see what comes out of this.
Well, and you've done an outstanding job, I think, and it was a pretty tough task to literally cover an 11-year period, and I think you did it very well and did it within a reasonable time frame. So now that he has brought you up to speed on current, and we certainly would love to have other segments of the interview, because there's been other things other than just this, and if whatever he would like to do, we're going to have the segment for it. But I want to make sure everyone knows we will keep you updated on the civil trial all the way through. Now, he's done a great job to where now I don't have to go back from ground zero, because trust me, that would have been a tough task. And even though I went to all the hearings, he knows it because he's lived it. Thank you so much for doing that, and you have our commitment, or my commitment, that we are going to continue to keep you apprised of the developments in that civil trial going forward. With that, Murphy, thank you again for the enormous amount of time you're willing to invest into this. I think it's extremely productive. I wish I could take back what you've had to go through, but I don't have that ability, so all I can do is try to help you, as you said from segment one, get your side of the story out there.
I appreciate your professionalism.
Well, thank you.
Thank you.
All righty, we'll see y'all. We'll have other Sound Off episodes coming, but we'll see you for, this is seven, so we'll look forward to delivering episode 8. I'm sure he'll have something he can let us know for episode 8.
One more, hopefully.
All righty. Thank you once again, everybody.
Appreciate you.